arbitration agreement functions as a clause or provision in a signed contract between at least two separate parties. Through an agreement, the parties can consent to settle a potential legal dispute outside of court. Instead of taking part in courtroom litigation in the future, the parties agree that they will have any sort of civil disagreement get settled through arbitration. Do you own a cell phone or credit card? If so, chances are that you signed an arbitration agreement without even realizing it. In fact, you might have even signed one of these agreements when you started your current job. Since the average arbitration agreement is just a small paragraph or two long, many people sign agreements within consumer or employment contracts without knowing what arbitration even is. Arbitration is a private legal procedure similar to that of a court case in litigation. Hearings take place in front of an arbitrator or a panel of arbitrators who serve a similar role to that of courtroom judges. The parties present evidence and interview witnesses in private conference rooms. Then, the arbitrator makes a binding legal decision that permanently resolves the dispute. In most cases, the decision of an arbitrator cannot be appealed. As a result, parties can move on with their lives instead of appealing the terms. So, why do many companies and employers prefer arbitration over litigation? It comes down to reducing costs. Arbitration is on average much cheaper and faster than litigation in a courtroom. Plus, unlike court litigation, the information revealed in arbitration stays private and out of the public eye. If you own a business or thinking about starting one, it might be in your best interest to have your customers and employees sign arbitration agreements. This way, you can save time and money if a civil legal issue takes place. Your average arbitration agreement or clause is only a few sentences long. If you can find an agreement near the end of a large contract, and you might see it below a heading titled Dispute Resolution, Arbitration, or something similar. This concept also applies to employee arbitration agreements. They often get buried within the pages of an employment contract. But sometimes you can find arbitration agreement terms inside an employee handbook. Some contracts only state that certain types of legal disputes can be arbitrated. Others might demand that arbitration take place if any form of civil disagreement arises. An agreement might also define exactly how the arbitration hearing process will be conducted. For example, specific arbitration rules might go inside an agreement. These rules often come from an arbitration association or organization that has a relationship with a company or a party that is using the arbitration agreement. As you may have guessed by our name, arbitrationagreements.org specializes in drafting arbitral agreements for individuals and businesses all across the United States. Please contact us today if you need help creating a world-class arbitral agreement or clause. You can even give our association a phone call right now at 844-554-0444. Keep in mind that in addition to drafting premium agreements, our experts can assist you with every aspect concerning arbitration, from accessing a roster of distinguished arbitrators to booking conference room hearings in your local area. There's no limit to what arbitrationagreements.org can do for you or your business. We look forward to helping you succeed.